Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. In this video, we are going to discuss an important point to know whether a public servant as a witness, if turns hostile, can be taken as perjury or not. The answer is no, but after deliberations, after so many citing of so many case laws, then only it has come to as a judgment by the Honorable Supreme Court of India. Right. Yeah. We are going to discuss a case law on it. Recently, that is in 10th month, decided by Maharashtra High Court, particularly Aurangabad bench. You can read the case as Abdul Rauf Muhammad Khaza. Abdul Rauf Muhammad Khaza versus State of Maharashtra and others in writ petition number 2352 by 2018, and the decision was given by two judges bench, Justice Mangesh S. Patil and Sandeep V. Marne on 14th October 2022. Right. So please remember, the honorable bench, two judges bench, clearly observed that turning hostile by a public servant does not amount to perjury, which is an offence punishable under section 191 of the Indian Penal Code. Now let us have a quick look at 191. 191 deals with giving false evidence. Whoever being legally bound by oath or express provision of law to state the truth. And please remember, if he makes any statement which is false or which he knows that it is not true, then it is called giving false evidence. Of course, the penal section is under section 193 Indian Penal Code, where it is up to 7 years is there. Here, when he turns hostile, doesn't amount to perjury. Please remember, perjury, it has to be decided by the court, particularly the sessions court. So whenever they give permission, then only the case can be treated as perjury. And whenever it is mentioned in the judgment, yes, he can go for perjury. Otherwise, you have to treat him as hostile witness, and his witness evidence is of no value. That's all. This is what is stated in this particular case. So going to the facts of the case, actually the accused, that is appellant here, Abdul Muhammad Khaza, he was working as a peon in a particular department. Actually, he witnessed the accused throwing away the victim or the deceased from the terrace. So he has seen the incident, and due to which this man died, and a case of murder was registered against the other person who threw the victim down. So since he has seen the incident, and since he was an ocular witness, his statement was got recorded under section 164 CRPC. You know what is 164 CRPC? Only 164 CRPC means statement recorded before a magistrate. It becomes, it has got sanctity. Why? Because they wanted to strengthen the prosecution case. For strengthening the prosecution case, yes, they will produce the witness before the magistrate or judicial officer. They will record the statement. There is certain procedure they will follow. It is giving much more weight. But here, even though the 164 statement was recorded, during the trial, the peon fumbled. The peon could not give evidence properly. Ultimately, he was treated as hostile. And since he declared hostile, and basing on some other facts, not only this, coupled with some other facts, the case ended in acquittal. Now the department has taken a serious view, and they wanted to go for, actually they have filed a case of perjury against him. Now the Honorable Aurangabad bench case, they have realized So they have relied on a Canadian Supreme Court case, very important case, Canadian. This is Pierce versus Foster, P-I-E-R-C-E, Pierce versus Foster, 1959 case. No doubt. Here, actually, their wording are different. They have stated that it is a blameworthy code of conduct. Blameworthy code of conduct. So, if a public servant conducts in such a way which is inconsistent with due and faithful discharge of duty, it is misconduct. So they held it as misconduct, not perjury. So perjury means, please remember, as per section 160, 191 CPC, no doubt the magistrate or the judge has to, after considering the testimony of the witness, here more, after considering the testimony of the witness, the session judge should refer the matter to the police or to the judicial magistrate to take action under perjury against the concerned witness. But here what happened is, the judge tried to make him try to go to the topic of perjury, but it is not, the evidence is not sufficient. It is only hostile, that's all. He has not deliberately become hostile. Due to confusion, he became hostile. Whatever be the reason, but here, after considering all the facts, the session judge thought that it is not necessary to issue notice for trial under 191 of the Indian Penal Code, that is perjury. So please remember, the turning hostile does not amount to the so-called perjury. It's only, it may amount to misconduct. Normally, please remember, morally, we will expect, one may morally expect a particularly witness, public servant, to stand by his statement, to stand by his previous 164 statement, and he has to speak the same in the trial. So please remember that too. If he is a public servant, if he is a government servant, higher degree of responsibility could be expected from him. But still, turning hostile does not amount to so-called perjury. For perjury, deliberate intention should be there. So there are so many grounds. Normally, the session judge will decide. So without that, you can't come to the conclusion that it is a perjury and you cannot punish him under 191 of the Indian Penal Code. This is what is held in this particular Abdul Rauf Muhammad Khaja case. So very important case. Please read it and enrich your legal knowledge. With this, I am concluding. Thank you very much.